Welcome everybody who's joining this first seminar in our 6-part online seminar series, a framework treaty on business and human rights, interdisciplinary insights. My name's Claire Methven O'Brien. I'm a Baxter Fellow and a lecturer at the University of Dundee School of Law, and I'm also convener of the University of Dundee's new Business Human Rights Network and its newly established LLM on business and human rights. First, I would, of course, apart from welcoming you all, like to gratefully acknowledge the support of an interdisciplinary incubator grant from the University of Dundee Institute for Social Science Research that's supporting this series. I'm also immensely grateful to the group of leading international experts who've agreed so very generously to give their knowledge, insights, and their time at a very busy point in the academic year for many of them to serve as panelists across the coming 6 seminars. And with the benefit of their input, we aim in this series to explore in greater depth key questions relating to the proposal for a framework style convention on business and human rights. And why should we consider this topic and why now? I will just briefly touch on that for participants who may be wondering that or who may not have spent a lot of time thinking about that up till this point. The framing for this series is that the world does face currently unprecedented interlinked environmental, economic and social challenges which have got profound implications for human rights across world regions. Besides climate change, we are experiencing catastrophic biodiversity loss, unsustainable resource consumption, as well as demographic change and deepening global inequalities, as well as trends of asset concentration, as highlighted amongst others during the COVID-19 pandemic. Meanwhile, financialization of the economy and the commercialization of the public sphere, as well as private communications through the activities of tech giants and in other respects, carry implications for democracy's ability to sustain and reproduce itself that are still emerging. Now, corporations and their activities, their influence, their incentive structures and business models are deeply implicated in almost all of these problems. This raises the question, through what international standards and mechanisms should corporate human rights impacts be addressed? Recent decades have witnessed something of an explosion of new initiatives in this area, from individual company codes of conduct dating from the 1970s, as early as the 1970s, to multilateral trade, investment and financial instruments, new rules on sustainability reporting, and a variety of supply chain legislation. In the United Nations, attempts to define international human rights standards addressed to businesses or otherwise intended to control or regulate their impacts have spanned several decades. Recently, in that context, in 2011, the Human Rights Council endorsed the UN Guiding Principles on Business and Human Rights, UNGPs, a soft law framework, as well as the UN framework on business and human rights, encompassing the state duty to protect against business-related human rights abuses, the corporate responsibility to respect human rights, and the right of victims to effective remediation. A parallel process to develop a business and human rights treaty was launched in 2014, but has so far struggled apparently to make significant progress. Significant actors remain outside the process, while others continue to register their reservations to the overall approach or scheme of the instrument envisaged, as well as specific aspects of its content. In that setting, since 2007, in actual fact, I've proposed a framework-style treaty on business and human rights. And in recent years, there has been increasing interest in this proposal as a possible route to break the impasse, as it were, as regards a UN Business Human Rights Treaty, with discussions being convened within the last year by the United States and Japan, in the European Parliament, and by several academic institutions. So needless to say, views do differ amongst academics as well as other policy actors and civil society entities, business and governments, on the strengths and weaknesses of a framework approach to a business and human rights treaty, relative to that embodied by the current text from the intergovernmental working group process. And for that reason, this seminar series aims to explore the contours and challenges that might be faced by a business human rights framework instrument, how such an instrument might operate in practice, what governance challenges it should address in particular, and the wider context of global governance challenges in which the business human rights agenda sits, at how to link a framework convention to existing business and human rights governance constellations, encompassing private regulation, mixed public-private regulation along supply chains, specific sectoral standards and so forth, and how finally the treaty process might advance in a productive direction in diplomatic terms. Now, if you want to join, you're listening and you would like to join later seminars in this series, further details are now available on the University of Dundee Business Human Rights Network webpage. I think Ben will post a link in the chat, and you would need to register for each of those seminars as you have done for today's. So in terms of logistics for this seminar today, we will add format. We intend to have lightning contributions from each of our distinguished panelists, who I'll briefly introduce in a moment. We will have time at the end of the series of expert presentations for Q&A, question and answer with the audience. So please do raise your hand, your virtual hand, to ask a question when the time comes, or place your question in the chat. Now, today's panel in particular will focus on examining the operation of framework style instruments in other policy domains beyond business and human rights. And that includes the fields of international labour regulation, Indigenous people's rights, the environment and climate change, as well as existing international human rights treaties. The panel will look at the strengths and challenges of framework instruments in these contexts, their normative structure, and the institutional design of the regimes associated with them, as well as factors influencing how effective they may have been or could be in practice. And the aim of this discussion is, of course, to provide a platform to reflect on the possible merits of a framework style approach in the business and human rights domain. And I'm delighted to welcome Dr. Claire Charters, Professor Shin-Ichi, Dr. Annalisa Savaresi, Professor Barbara Koremenos, who I think, I hope will join us shortly if she's not already on the platform, as well as, and she is, welcome, Professor Koremenos, great to see you. And finally, Dr. Jacques Hartmann of the University of Dundee, who was scheduled to join us in a later seminar in the series, but has graciously agreed at short notice to bring forward his presentation until today's meeting, as Professor Steve Ratner, who was scheduled to join us today, has had to withdraw, although we hope he will participate later on in the series. So I would, in the interests of time, propose to include the impressive biographical details of our panelists in the chat, so Ben will post the biographies as the panelists are speaking, so that you can enjoy their impressive biographical details, rather than taking time from the discussion that we might have later on with participants. So with that, I would like, if you were ready, Professor Koremenos to start with you. And Professor Koremenos has undertaken impressive empirical research on human rights treaties, as well as on framework agreements and other contexts, while also looking at theoretical aspects of coordination problems that, amongst other things, may be less familiar and more challenging for the legal fraternity, the legal scholars and practitioners perhaps who are joining this discussion. So I wonder, Professor Koremenos, could you help, especially those of us approaching the Business and Human Rights Treaty discussion from a more normative starting point, could you help us navigate and understand some of the key implications of the research you have conducted?
Thank you so much. So I can begin, and you can see me because I can't. Okay, great. So I'm really eager to hear all of your issue area expertise. So I thought by starting out, I could tell you about variables that I have discovered that are important in treaty design. And while I've mostly analyzed legalized binding treaties that are registered with the United Nations, within those treaties, there's a continuum of soft and hard law elements. If we want to think of the particular softer law elements, things like not being very precise or being allowed to opt out or add reservations, escape obligations, those kinds of things. And so when thinking, I believe that this theory can be applied just as easily to treaties versus frameworks, especially because I don't think it is a yes or no, that there really is a continuum. And I think, Claire, you've said that in some published work as well. So the first thing that I always think about when thinking about agreement or cooperation design is how crucial is the behavior of others to my own decision? In other words, am I in a public goods free riding type of situation as we currently are with curbing emissions and climate change, where we would prefer to free ride off of others' cooperation? Or are we in the kind of more typical human rights context, like thinking about the rights of the child, where we want our norms to be embraced by other actors, other countries, but if they don't embrace those norms, we don't want to suddenly change our norms. There's no free riding off of human rights norms. So if you don't allow your girls to attend school, I still want my girls to attend school. But if you don't curb emissions, I don't want you to free ride off of my curbing emissions. And then characteristics of the party in the aggregate. How many parties are there that have to cooperate? And what is the degree of heterogeneity in terms of preferences? How many have already embraced some of the norms that would be embodied in the cooperative agreement? And even things like, and we can probably go to the next slide, to what degree are the most powerful actors already embracing the norms? That can matter a lot for getting that framework or treaty off. Now, with respect to business and human rights, I think one of the key questions, therefore, is where are we how much of this is business and some of the competitive pressures, race to the bottom type of calculations versus more like a typical universal human rights treaty. We can go on to the next slide. So in my empirical and theoretical work, I have shown that human rights cooperation is characterized by flexibility. There is no one size fits all because of the great heterogeneity with respect to regime type and norms that are embraced. Human rights treaties are significantly less precise than other agreements, and they tend to have more reservations lodged. Now, to me, this isn't bad news because it can help get cooperation started, which would otherwise be stymied. And over time, empirically, it's been documented that the norms become more precise, sometimes through the decision of judges, sometimes through a set of sequential human rights agreements covering the same issue area, and reservations are withdrawn, sometimes under pressure from the International Law Commission or NGOs, but often because a new generation of citizens has already embraced the norm. So in human rights, we don't have a free riding problem, but there is a lot of uncertainty about behavior. By that, I mean that no matter what laws countries have on the books, it's very difficult to tell what they are actually doing, right? So they may say girls can go to school, but are girls really allowed in school? And when they are going to school, are they learning math, or are they just learning, to prepare for marriage? So information is key, but enforcement and punishment, as Beth Simmons has shown, can be left decentralized. So we basically allow these differential commitments. The next slide is just something from Tom Schelling. I think I'm going to skip over that pretty quickly because it just illustrates the free riding problem. I will say that free riding problem, I think, captures situations of weapons of mass destruction, trade, climate change, alliances. It isn't clear to me to the degree to which it captures business and human rights. These are the way that formal treaties incorporate soft law elements, so they are less likely to have delegated monitoring. If there is no free riding incentive, they're less likely to have delegated monitoring and information collection. They can rely on self-reports. They do not require a formal permission to escape, or to derogate. They are less likely to have formal punishment. They are less likely to have delegated dispute resolution. They don't have long withdrawal notice periods. You don't have to give 12 or 6 months notice, and they are less likely to prohibit reservations. So within the hard law universe of legally binding agreements, we see agreements for which free riding is not the main concern, incorporating a lot of these softer provisions. Next slide, and thank you, Ben. And so what we gain from a framework or soft agreement is communication, information sharing without fear of consequences, learning best practices, and sometimes, and we have seen this in the human rights context, they are stepping stones to legally binding commitments with enforcement provisions. That seems to be the history of some of the human rights regime. There have been a lot of softer environmental agreements in the 80s after the Earth Summit, as we were trying to encourage norms around the world. What remains to be seen, and it's too early to tell, but I think a lot can be learned in a couple of years, is whether this has been successful in climate change. With the Talanoa Dialogue that was created in 2017, is that going to help us to get to what we really need in terms of climate change, which is a legally binding and very enforceable treaty? Or is it going to take us off track? And I think that opinion is very split, and we won't know for a while. So we can skip a couple of slides now and just get all the way to the Paris Agreement slide. Actually, we can go even further. Some things, that's a great one there in terms of where is the source of the distribution problem. Is it international, where some firms and businesses in particular countries have very different sets of norms that they'd be willing to embrace than others? Or is it a domestic distribution problem where, you know, I mean, that's just seems to be the biggest thing that I'm experiencing over the past, you know, 5 years in the United States, where the big problems are within the country and disagreement about burden sharing and things like human rights, or both? I think that's an important question. I think I just have a couple more slides of variables to think about. How important is the legislature to the cooperative endeavor? Is money needed? Is there domestic implementing legislation needed? If the answer to either of those is yes, frameworks don't always cut it. And what signal is sent to the rest of the world or to other actors when the agreement doesn't require legislative approval? Is that showing that the commitment may not be fully there because the agreement was done through, in the United States, what we call an executive route, executive agreement, and essentially bypassing the legislature. So 2 more slides. Again, basically just recapping and ending with how important is other actors' commitment in deciding whether to comply with my own commitment. I really don't know where business human rights agreements land on the blend of economic and human rights, because these would be pushing us in 2 different directions. But one more optimistic final slide, and that is, can public opinion help sway actors, even in the economics context, such that the framework can serve as a stepping stone to agreements that legalize nascent norms? And 2 examples of this, the Whaling Treaty, it was legalized from the start, but it very much changed over time. And I think it illustrates how public opinion can help change the commitments actors are willing to make. So in 1975, there was a Save the Whales campaign, letter writing, whales are mammals. And, you know, before you know it, it changed from a quota system to an actual prohibition on killing whales. The Antarctic Treaty actually started before it was officially the Antarctic Treaty. It was a gentleman's, as they call it, agreement during the International Geophysical Year that Antarctica should be used for only scientific purposes, very cooperative. It went really well, and then President Eisenhower invited the countries that participated in that geophysical year on Antarctica to Washington, D.C., and within a year, they had negotiated the Antarctic Treaty, which essentially legalized everything that had happened during those years. So there is room for optimism in framework, even when in these contexts that could be characterized by free riding. Thank you.
Thank you so much, Barbara. I think it's very interesting that the sort of analysis that, you know, your work points to as regards, you know, the extent of cooperation problems, number of parties, and the other variables which you've identified in your initial presentation there. I think, you know, that analysis, as to my knowledge, hasn't been undertaken as regards the Business and Human Rights Treaty problematique as yet. Perhaps participants, you know, to this seminar may correct me if I'm wrong there in the chat or later through questions. But I think that this kind of political science, you know, from a lawyer standpoint, analysis of the business human rights objective and problematique has not yet been undertaken, and it of course could be incredibly valuable to those of us approaching the issue from other disciplinary perspectives to you know, to have our own perspectives enriched by some of the insights that would yield. I mean, I did have quite a few follow-up questions of my own. I don't want to abuse my position as chair too much, and perhaps other panelists may also have had some questions that they would like to raise with Barbara in response to what she said already. But I wondered, one particular question that I had was when you said where legislation and money, you know, the engagement of domestic legislatures is required, that frameworks might not cut it, as you said. And I wondered if you could just elaborate a little bit on, you know, the dynamics of that and why that's the case. And then perhaps, I don't know if any of the other panelists have got burning immediate questions, maybe we could come round to you for those.
Here's where I wish Steve Ratner were here, because he would be able to answer what this means in the US context. But I'm thinking of like cooperation for international coffee, you know, back in the late 60s, 70s, when we were, the United States and Europe were trying to support essentially a coffee cartel. And we had to fund the International Coffee Organization. So the same thing might be true for future pandemic cooperation. When funding of a particular international organization is necessary, then these tend to have to be agreements that can't be simple executive agreements like the Paris Agreement. And because they require legislative approval because of funding in order for them to be fully implemented. I don't think that tends to be the case with a lot of human rights agreements in the same way as economic agreements like a NAFTA, you know, so anything that has to do with money, at least in the United States. But there's also been some work by Lisa Martin. It's been a while and I'd have to look at it, and a little bit more recent work, but that I actually have some problems with, so I won't say the author, about whether there's a stronger signal. You know, I think it might be some kind of a game theoretic model. I'm not sure I really quite believed all the assumptions, and so I tend to discount those if they aren't resting on very realistic assumptions about whether two other countries, they believe that the commitment will be more forthcoming if the legislature is on board. Even if there's not money involved, would there be, you know, laws enacted that would, you know, force businesses to pay attention to human rights, to report to some kind of a centralized federal agency about what their practices are? You know, if those kinds of things were required under a business human rights treaty / framework, that's where what we're requiring of sub-state actors. How much does the federal government need to be involved through new legislation? I don't know if that clarifies anything, but.
Well, I think it shows how much, yeah, further reflection is required around that, those dimensions of, you know, business human rights instruments, and, you know, how they could be differently articulated. Also, you know, very much around the issue of competition, of course, that you've flagged, but how this plays out, I think, is going to be incredibly complex in the context of business human rights treaty and along multiple dimensions, but certainly requires more engagement by many of us who purport to have, you know, positions on the business human rights treaty topic. Okay, well, in order to keep things moving, since I think actually Dr. Hartmann has some remarks to provide in relation to what is a framework convention. And I think, you know, given that we are a cross-disciplinary group amongst the panel, but amongst participants as well, probably would be useful to bring that set of that information into the discussion at this point already, just to sort of clear the ground for some of the later contributions, looking at the operation and effectiveness of framework conventions specific contexts. So Jacques, I'll pass the word to you now at this point. Thanks again, Barbara.
Thank you very much, Claire. Yes, so what I was going to do today was to explain, first of all, what is a framework convention, and then I'm going to mention some of the pros and cons, basically, of using this way of lawmaking. So the first thing I think we need to understand is that a framework convention is not really a technical term. It's not a legal term of art. there's no legal meaning basically to call something a framework convention, and the term is not mentioned in the Geneva Conventions on the Law of Treaties. But it's still a useful phrase, and I'll explain why. But we should also say there's some discrepancy in the literature. So, for instance, many textbooks of international law says that framework convention is a relatively new term or recent term, they'll say. But if you look at some of the treaties that are normally classified as framework convention, then they are not that recent. At least quite a few of them are older than I am. So that could, for instance, include the Convention for the Protection of the Mediterranean Sea Against Pollution, which is also known as the Barcelona Convention, which was adopted in 1976. So you can start calculating how old I am. Or the International Convention for the Prevention of Pollution from Ships, a very famous convention, which is called the MARPOL Convention. And that was adopted in 1973. And I'll use that as an example, basically. Now, the MARPOL Convention establishes the international regime for the regulation of ship-sourced marine pollution. And the reason that we consider the MARPOL Convention a framework convention is that the original treaty or convention, in international law we use a lot of different terms, has very few substantial provisions. So there are issues on institutional and jurisdictional matters, but there are very few substantive obligations in the first convention from 1973. But these detailed obligations were then included later on in what was called annexes, but we could also call them protocols, for instance. So there's 6 of these. And just to kind of give you an idea, I'm just going to go through the titles of these, and I know it can be a little bit tedious, but the titles give us a good indication. So the first one from 1983 concerns the regulation for the prevention of pollution by oil. Then we have a later one, number 2, which concerns control of pollution by noxious liquid substances in bulk, so in bulk ships, also from 83. Then we have one from pollution by harmful substances carried by sea in packaged form, very specific, from 1992. And we have one on pollution by sewage from ships from 2003. We have one on pollution by garbage from ships from 2005. So basically what we get is the MARPOL Convention sets up a framework, and then we get very detailed regulations in later treaties, in protocol, or in this case, annexes. So what are then the characteristics of a framework convention? Well, what a framework convention does is that it creates a general system of governments and not, in most cases, a specific obligation. So Professor Koremenos said that you could look at it as a continuum, and I think that's a good way of looking at it. We don't necessarily have a strong definition of what a framework convention is, but there's something that very clearly looks like one, and then there's something that just have elements of it, and then there's something that doesn't look like a framework convention at all. But what we'll typically see is that it establishes broader commitments for the parties, but leaving the specific targets or goals in subsequent and more detailed agreements. So these we usually call protocols, but in MARPOL it will call annexes. Or sometimes it's left to national legislation. Now the overall aim, for instance, the overall aim of limiting ship-sort pollution in the MARPOL Convention is then put into effect by these later treaties. And other characteristics or other ways of achieving this aim, for instance, is to establish institutions or follow-up mechanisms. So we, for instance, have regular meetings of state parties. In some treaties in the climate regime, for instance, they're very famous, they're called COPs. We have one coming to Glasgow soon. We can have institutional arrangements like a secretariat that specifies certain existing organs. And we can also have, for instance, compliance monitoring institutions, which could be made up by national experts. So in essence, what a framework convention, a framework agreement does is that it serves as kind of an umbrella document, which lays down the principal objective and the rules of governance of the subsequent treaty regimes, which will then be developed in later stages. Or we can also, for instance, say it's a constitutional document under which later treaties can be established. Now, there's quite a lot of examples, but just to give you some. So we have the Vienna Convention on the protection of the ozone layer from 1985. which leads to a series of protocols and amendments and also institutions. And of course, the most important protocol was the 1987 Montreal Protocol. And then we have today a secretariat in Nairobi. We have the United Nations Framework Convention on Climate Change from 1992. It's a very famous treaty, a very famous framework convention, which led to follow-up conventions such as the Kyoto and the Paris Agreement. And of course, we also have a Conference of the Parties, and we have a secretariat, which is in Bonn. Or another example could be the Convention on Biological Diversity from 1992. Again, we have a subsequent protocol, the Cartagena and the Nagoya protocols, and we have governmental and expert bodies set up, and we have a secretariat in Montreal. So these are all kind of classical examples of a framework convention. Now, why would states then choose to use a framework convention in their lawmaking process? Why don't they just make or have one treaty that puts in all the rules and obligations and all the institutions that can be created in one document, and then that's it? Well, there are quite a lot of reasons why states might choose a framework convention. One is that it can be a very complex issue that has to be regulated, and it simply takes more time. So it's better to have a kind of institutional framework that then incrementally deals with the problem. We can also have changing scientific facts, so that we might not know all the facts at the specific time. And this way of setting up an institutional framework then allows us to deal with uncertainties or new knowledge. There can also be an anticipation of racketing up or increasing standards over time. So we might only today be able to reach an agreement on a certain level of standards, and then over time, we want to basically increase that standards. And that's one thing that framework conventions are good at doing. Or we might face simply political inability or a lack of political will to deal with comprehensive issues today. And then we set up this institutional network, sometimes that is quite far away from the political decision-making process, that makes it easier for us to make detailed regulation on issues that could be quite politically sensitive. And we also know from the lessons from other treaty regimes, for instance, if you look at the Convention for the Law of the Sea, which is a very, very detailed treaty, even though some elements of it could be considered a frame convention. Now that was negotiated from 1973 to 1982, so it took a long time. So a framework convention can be a faster way. And then there's some more technical aspects as well. That could be the reason that we might go for a framework convention. And that is, for instance, that it can be easier to revise. So we can kind of negotiate or agree our way out of the standard procedures for modifying a treaty, which of course we find in the Vienna Convention on the Law of Treaties in Part 4. And normally it takes consensus from all the parties, but we can set up different systems where we can amend a treaty, for instance, by a qualified majority. So those are some of the reasons why we might prefer a framework convention. And if we look at, for instance, business and human rights, are very technical and they can have very wide-reaching consequences, also very political in some areas of this. So a framework convention could be a good. Now, what then are the disadvantages of having a framework convention? Well, when we put off difficult decisions, we do run the risk that no decision is ever taken on these difficult decisions, and we have seen that before. There's also, of course, the possibility that views or the political consensus changes over time, and instead of slowly or incrementally increasing standards, what we see instead is that we actually lower standards because states in future meetings want to lower the standard. And then there's also, of course, the possibility that we go for a framework convention because we underestimate the possibility for consensus on a comprehensive agreement. And there we can take an example, for instance, from international criminal law. So in 1994, Trinidad and Tobago presented this idea, suggested we should reconsider having an international criminal court. And there was a lot of debate about that and uncertainty of how fast it could be drafted. Well, it was drafted from essentially over a few years from the suggestion was made in 1994. We had the treaty already in 1998 and it entered into force in 2002, which by international standards is incredibly fast. So you do run the risk basically that you underestimate the political will. And we should not underestimate the importance of political will. So we see, for instance, many of the human rights treaties were negotiated just after the Second World War or after specific events that kind of galvanized political opinion on the international stage. So while framework conventions are not a specific legal term of art, it is a useful kind of analytical framework for which to understand how a treaty works. And I think it's probably better to see it more as a lawmaking process than a specific category of treaties. And they can be used in many scenarios. They're often used in environmental law, but not necessarily there. And they can be a very good way of basically incrementally increasing standards in complex area of lawmaking. So thank you very much for your attention.
Thank you very much, Jacques. And I think that provides the perfect point of departure for the subsequent presentations of the panel, which will look more specifically at, the incidence and the operation of both framework style instruments and other sorts of international legal mechanisms and devices in these, three specific areas of international labor regulation, indigenous peoples' rights, and also climate and environment. So I think actually, if no one objects, I would actually move straight into these three panelist contributions just to maintain the continuity of flow of the discussion. And I'd like to pass the word first to Professor Ago, who has long and extensive experience, not only as a scholar, but also as a practitioner in a context of international labor law, and has recently written a paper from that perspective, looking at the relative strengths and challenges of soft and hard law instruments, potentially in the field of the international regulation of business and human rights. So could I pass to you, Professor Ago, to share with us some of your thoughts and reflections?
Thank you, Claire. Can everybody hear me?
Yes.
Good, thank you. Thank you for inviting me to this highly interesting panel to discuss the question of framework treaties. First of all, as Claire introduced me as somebody who has been also in not only in the academic works, but also in the practice, I was associated with the ILO in the sense of International Labour Office Secretariat for about 10 years in the 1980s, working for the International Labour Standards Department. And then I returned to academia, and now I'm again sort of back in the ILO as member of the Committee of Experts on the Application of Convention Recommendation, which isn't not in the Secretariat. It's an independent body established by the governing body to supervise, monitor the application of ILO standards. So my view, which I'm going to express, is a bit biased in the sense that I'm a fully committed ILO man. So whatever I say is what flows from my firm belief that the ILO's code is the best, and the machineries which it has developed is the best. So having said so, I want to make an initial point. I mean, my basic position is almost the same as Claire's initiative to propose a draft framework treaty rather than the something which is ongoing treaty drafting. But in one point, I'm a little bit different from Claire's position, that the framework agreement, framework treaty is not necessarily the best solution. I mean, I fully support the idea that framework treaty, as Professor Hartmann also described, is a good has a positive element and has contributed in developing international law in a new field of law. But at the same time, it has some drawback. And the drawback, the biggest drawback is that it has a so-called Achilles heel, so to say, framework treaty is a treaty. So if no country ratifies, it does not become effective. Or even if a certain number of countries ratify, those who are not members of the framework are outside outside the court, so to say. They are not bound anywhere. Now, so treaty making is good, but with that drawback, goes with that drawback. And here, with respect to the UN guiding principles, I mean the business human rights context, the treaty has another weakness of not being able to address directly subjects which are not subjects of international law. That is to say, the treaty cannot directly apply to corporations. The traditional principle of public international law is that the only subjects of international law are states and international organizations. Of course, with the development of human rights law, it has changed a little, but the basic principle stays. Now, so under this context, I think a treaty, even a framework treaty, may not be the best solution to tackle the question of business and human rights. And then answering to perhaps Claire's questions, which she had put to us at the very beginning of this project, what institutional design would be needed to make a framework treaty regime effective, and what lessons can be learned from experience under other international framework treaties. I wish to give you some insight into the ILO's experience with the intention to support the Claire's initiative of proposing a framework treaty rather than a rigid treaty, so to say. The ILO has been working already more than 100 years, 101 years to be more precise. In this context, I wish to make a small correction to Jacques Hartmann's presentation a few minutes ago, when you said all human rights treaties have developed after the Second World War with the United Nations. But you must know that the ILO existed from 1919, and the very first Human Rights Convention was Convention number 29 on forced labor. And since then, the ILO has been quite elaborating various human rights treaties, not strictly related to labor matters. So a small comment I wanted to make at that point. With 100 years experience, the ILO has adopted nearly 200 conventions, among which there are some which are called promotional conventions in the ILO's language. And among those promotional conventions, there's even one which is called Promotional Framework for Occupational Safety and Health Convention, number 187. That is really a framework convention with the title itself, framework. And it envisages some sort of protocols to be adopted later on to materialize and concretize, to crystallize the essential idea of the framework. Another famous convention in social security matters, Convention number 102 on minimum standards in social security, has also a sort of soft element in it, sort of flexibility in the sense that member states can ratify, do not need to ratify the whole convention in one set. They can choose to ratify a part of them. At least one of 3 parts must be ratified, but 2 others can be left for later exercise. There's also another famous convention, 122 on employment policy, that obliges member states simply to declare and pursue a policy of full employment, full stop. That's all. That's only one sentence in that convention, which is in a way, yeah, I would call it also a framework convention because it doesn't set the legal requirements there. And everybody at that time when 122, Convention 122 on employment policy in 1964, I forgot, was adopted, thought that it would not live long. It is not viable legal instrument because it has been drafted in such a abstract manner. But what happened was that the ILO, with its famous, well then I'm praising myself in a way, very well-functioning machinery of monitoring the application, the so-called supervisory bodies, both the Committee of Experts on the Application of the Convention recommendation, which was established already in 1927, and then the Application of Standards Committee of the Conference, which also started off almost at the same time, or even earlier. And with these supervisory bodies, it was possible to make these quite soft instruments harder, so to say, by continuing to make comments, observations, how to implement this almost impossible, legally impossible document. And now I think one convention on employment policy has become almost a valid legal instrument. So what we can learn from this experience is that whatever it is needed, regardless whether it's a convention or recommendation or resolution or whatever, whether it's a hard law or a soft law, what is important is to have a machinery to supervise, machinery to follow it up and monitor the application of these conventions. And I think it is really important in the case of United Nations Guiding Principles on Business Human Rights that this happens, that is to say, to set up a sort of machinery to follow it up. Because, as I mentioned a few minutes ago, treaty can bind only member states, but the UN Guiding Principles try to make companies also abide by. And since treaty cannot directly address companies, but only can do that through the channel of governments, that's why treaty making is important, by the way. The sort of follow-up machinery should be set up in order to make the guiding principle more meaningful. And for that purpose, perhaps a very radical proposal is to make the working group, the current working group on business human rights, more authoritative as a sort of monetary machinery, like a treaty body, to ask governments to report on what they have done. Not only governments, but also companies, corporations to report on what they have done, and then follow up through this sort of annual meeting, which does take place already now with the Global Forum. You may have attended, which takes place every year in Geneva. So that is also, I think, this is what is most important is to have such a kind of follow-up machinery, regardless whether it's a soft law or hard law. So in case of Claire's framework treaty, I think what is most important is to have a follow-up mechanism attached to it. And you have a sort of conferences which come subsequently later on to draw up protocols and so on. But I think there must be some sort of permanent secretariat, permanent body to set up to regularly follow it up. So with this, I end my presentation. Thank you.
Thank you very much, Professor Ago. And I think certainly will be very helpful if Dr. Savaresi and Dr. Charters in their presentations next can also share with us their insights on the nature and quality of follow-up which has been achieved under the instruments they'll respectively address. And I think it will be interesting maybe to take up in questions after those presentations also your proposal, Professor Ago, around strengthening the existing working group on business and human rights, making it function more like a treaty body, and to what extent that might be possible, feasible, or sort of optimal if it were done without there being a context of an internationally binding legal instrument, whether a framework convention or another, providing a mandate for such a treaty body on business and human rights. So hopefully we can come back to that cluster of issues later in the discussion, as well as in our subsequent seminar in the series, which will look at specifically at different possible modalities of institutionalizing and providing a supportive regime for a new international instrument on business and human rights. And maybe just before I pass to Annalisa and Claire, I should also just highlight, perhaps should have done this at the outset, some of the key features for anyone who hasn't yet read the text, the framework text that I've proposed on business and human rights. I think Ben, if Ben hasn't already posted links in the chat to my proposed 2020 business and human rights framework text, which I've also updated in a revised version this year, just to provide the sort of key features and in outline of that. One is a statement of the overall objectives of the instrument, which would align with the UN Protect, Respect, Remedy framework of 2008, but which are also sort of given a slightly more expansive formulation in my 2021 treaty text, also to align with some of the concerns of the IGWIG text. The second main element is a statement of general obligations to be assumed by the parties, which include, for instance, a duty on states to take measures to achieve the treaty's objectives, as well as the UN guiding principles. Also a set of instrumental or procedural obligations to review systematically and periodically national law, policy and practice, to take measures to secure overall the effective implementation, monitoring and evaluation of the relevant principles on business and human rights. The third element is guiding principles for the implementation of the treaty, which include the guiding principles of 2011, but also which in my 2021 text, I've added some additional guiding principles, again, to better capture the concerns and the content of the IGWIG treaty text. And then finally, as Professor Ago was relating to us there, provision for a conference of state parties. which would have functions including developing additional guidelines and recommendations, considering the adoption of additional protocols or annexes, as Dr. Hartmann was relating, has been a key feature of other framework instruments, and also duties around international cooperation and interinstitutional engagement. So the idea of that model, which I think does echo much of what we've heard already from Professor Ago and from Professor Koremenos as well, is that the important thing is to capture consensus, the basis for consensus cross-regionally, to have a sort of critical mass of states who will sign such a treaty, to be able to address the very broad range of business and human rights issues which we already encounter, but which may also emerge in the future, which are issues which we haven't yet even contemplated, but also at the same time to have the possibility to develop deeper reaching, more specific binding rules on specific topics, as and when the consensus emerges among states and other parties, as well as sort of the technical know-how to develop specific rules on those topics, whether it's mandatory due diligence legislation or issues that arise in the context of specific global value chains or specific thematic standards, or indeed around civil remedies for due diligence failures or other topics. But to have the provision under the framework instrument to transact those kind of rules, but not to make the adoption of the treaty conditional on multi-party agreement on all the details of those specific rules across multiple domains in the first instance. So that's sort of the rationale and the overall vision of the Framework Treaty on Business and Human Rights, which I would propose. So I'd like now to turn, I'll turn first to Claire Charters, given the unruly hour that we've asked her to join us. In terms of her time zone in New Zealand. Claire, how do all of these issues which have been raised, both of a general, legal character and the sort of rationale that I've just provided for a business human rights treaty, how do they look from the context of Indigenous people's rights, both, sort of legally, theoretically, as well as given your extensive experience and involvement in the development and adoption of the UN Declaration on the Rights of Indigenous Peoples?
Well, kia ora koutou. Greetings, everybody. As mentioned, it's approximately midnight here, and I'm not usually up at midnight in front of a computer these days, so bear with me. It's a great privilege to be here, and it's wonderful to see so many friends here. Unlike Jacques with his youthful exuberance, I won't let anybody know approximately how old I am, although, as Claire mentioned, I have been involved with the Declaration on the Rights of Indigenous Peoples for quite some time now. I do want to touch on most of the points that you mentioned, Claire. I will go through my sort of 8 lightning points just quickly first, and then maybe we can draw it all together. But the first one is the Declaration on the Rights of Indigenous Peoples is obviously relevant to business and human rights generally, and you've seen that institutionally with relationships at the international level on that topic, and unfortunately also Indigenous peoples are often impacted by business from a human rights perspective in many places around the globe. So just wanted to draw that connection first. And the second point I want to make about the Declaration on the Rights of Indigenous Peoples is I'm not sure whether it's a framework convention or not, and that I guess relates to Jacques' point about what is a framework convention. There is no definition out there of a framework convention, but I was reflecting upon that, and I would think that in some ways it is not, in the sense that it has some very specific, quite comprehensive rights in it, particularly with respect to culture, with respect to non-discrimination, for example. The detail is in there. But in other ways, it is a framework convention in the sense that there are generic rights such as Indigenous people's right to self-determination, which is not clarified in great detail in the Declaration. And that reflects, thirdly, this idea of constructive ambiguity. And you were talking, various people have already spoken about the level of agreement, particularly Barbara, and how that comes about. And there was agreement on the specifics, but there wasn't so much on self-determination for obvious reasons. And so therefore the language was quite broad, and the only way that you could get people to sign up to it is if you had wide language that allowed different parties, state parties, but also Indigenous, to interpret it in their own way. Whether that's a good thing or not is perhaps another question. But after, almost 30 years of negotiation, 25 at least formally, I think people were a bit tired and needed that level of agreement to get it through. So what you can see, though, to the extent that there is some detail around self-determination, although very little, is that there is also fundamental difference in the understanding of self-determination reflected in general ways in the Declaration. So on the one hand, you've got expressions of Indigenous people's rights to autonomy and self-governance, so separation from the state, not being regulated by the state. On the other hand, you've got rights to self-determination to participate in the state. So that's a fundamental discrepancy or fundamental conflict, I think, in idea, but there is some elaboration of that within this broader context of the right to self-determination, but not specific like the rights to culture. I guess my fourth point is that what then happens when you have rights expressed at a very general level, or what has happened, what is happening, is that really pushes the interpretation to back into the domestic realm. So how states have a lot of freedom then to interpret the international norm as they like, and that's a real problem, as it turns out, for Indigenous peoples, because you don't want the all-powerful state determining what the Declaration means, and you can get some backwards movement away from what Indigenous peoples thought the Declaration meant or interpreted it to mean, and what states did. But states are interpreting that Declaration, have the authority to interpret it. So courts, for example, are using the Declaration, but not interpreting it in the way the Indigenous peoples might like. So you do have that problem of you open up greater space then for domestic interpretation, at least from where I sit. I can't talk for globally for implementation of the Declaration. So that opening up spaces and state control is a problem. So that was my fifth point. The sixth point relates to that, and that's that then the political and legal context in the state is really important to how that international instrument is then interpreted, whether it's positively, progressively interpreted, or whether it's watered down. And the political context domestically as in internationally will always change. There'll be ups and downs, but context is important, and sometimes the context in New Zealand might be very different, for example, than from somewhere else. So you can actually lead to a proliferation of understandings rather than the convergence that Barbara talked about by allowing that space there. At least I think that's the lesson from the Declaration on the Rights of Indigenous Peoples. I guess my seventh sort of lightning point is that at least for the Declaration, the hard law versus soft law distinction hasn't mattered so much. I picked up on Professor Argo's sort of point about you can have a treaty, but then it really matters whether someone ratifies it. And I guess in a ironic sort of way, and I say this kind of cheekily because I'm not sure if it holds, but a soft law instrument can often be seen to be more universal because you don't have to sign up to it or not. But certainly the experience with Indigenous people's rights is it hasn't mattered too much whether it is a soft law instrument, because incorporation and implementation has really depended on the political context domestically that I talked about before, which is very varied. And that Yeah, so I think that would be true whether it's hard law or soft law, but it's really that context which is determining it. And you've had some massive advances. So, for example, in Aotearoa, New Zealand, where I'm from, we've got a national plan of action happening. In Canada, you've got legislation now incorporating the declaration, and then other places less so. And yeah, so it depends more on the political context rather than where it's hard law or soft law, I think is my point. And then there's the 8th point is whether, and this relates to some of the points that Barbara was making and Jacques too, and I think Professor Argo as well, is that there's pragmatics around the political context internationally as to whether you pursue a treaty or not. There is not a whole lot of appetite amongst the Indigenous movement to push for a treaty, because there is a fear that once you go to a treaty, rights to self-determination will be watered down. And while they're left fairly generic, then we can argue for them to be stronger than maybe states might want them to be. Although I referred earlier to the opening up domestic spaces where states can control that. But there's a lack of appetite there, and it's pragmatic, but it's also principled as well for some of the reasons I've touched on. So just, I guess in sum, I would say that a framework agreement, to the extent that it might allow the constructive ambiguity that I referred to, as we've seen in the right to self-determination, the declaration, I guess to get agreement can be important. But then that, as mentioned, also opens up spaces for implementation for states to use that ambiguity to control then how it's interpreted domestically. As mentioned, the soft law, hard law distinction might not matter too much. What might matter more, and I pick up here on Professor Argo's point and your question then, or comment then too, Claire, is I think that's really true, that ongoing monitoring at the international level, making sure that the international level is also developing stronger interpretations of these norms is really important, and that might grow. And so part of the Indigenous lobby has focused more on increasing monitoring. So, for example, the expert mechanism and the rights of Indigenous peoples, its mandate was extended significantly in 2016, so that it now has sort of a quasi-monitoring role, can go into countries, a bit like a special rapporteur, and provide guidance on legislative development and so on. So I do really agree that you have to have that in the international level, because Indigenous peoples don't want their states interpreting their rights, because we haven't had much joy there. The purpose of going internationally is that it's taken us out of the state realm, so we do want that international monitoring. And, you know, Special Rapporteur, UPR, is really seized on the declaration. The Human Rights Council, Human Rights Treaty bodies are referring to the declaration, Permanent Forum, and so on. So I'll finish there. So hopefully that ties into some extent to the movement around a framework convention that Claire's talking about, but also generally around business and human rights. Anyway, I think there's some good lessons to be learned from the Indigenous context, not least because it was drafted over such a long period of time. So it's an interesting model in that sense. So kia ora everybody, lovely to see you.
Thank you so much, Claire. And I mean, if I may allow myself just a couple of quick follow-ups to what you said there, and the many interesting points. One, and you know, for my benefit, but also for participants, if you could just maybe elaborate a little on the MRIP and, you know, the sort of context, background, and the means by which as you just mentioned, the mandate was extended. You know, how long did that take to happen? Was that a difficult thing, or, you know, were there sort of was it a controversial move, or how was that managed, both sort of the normative and the diplomatic aspects of that, and also this, you know, key issue of the national political and legal context, and of course how that is articulated with international norm making, oversight mechanisms, and so forth. You know, is there anything that in retrospect, or, you know, in an ideal world, you would have liked or can see now could have been perhaps done differently in the context of the declaration, or, you know, in general? Is there any, you know, to optimize that dynamic, that positive dynamic, rather, and to minimize the space for backsliding and, destructive ambiguity instead of constructive ambiguity that you think might, carry over to in some way or to some extent for the business and human rights scenario.
So going to your first point about the increasing the mandate of the expert mechanism, that I think the people who were involved in that, including myself, were very surprised at how easily that happened, and some of us feel like we might have just hoodwinked states into accepting that extension of the mandate. And as I think all of us will appreciate, sometimes there are just little moments of opportunity in the international setting, human rights setting, that are seized upon, and it allows sort of great advances that are surprising. And I think the extension of the expert mechanisms mandate was one of those, and it relates to there just happened to be political will at that particular time. I mean, I don't want to overstate that because there is a long history to that, including the World Conference on Indigenous Peoples had happened only 2 years before, so there'd been this massive sort of international commitment to Indigenous people's rights, including monitoring. I think the expert mechanism had behaved in a way that hadn't upset states too much. There is a real, I think, dynamic there that instead of having a treaty, maybe you have a soft instrument with greater and better and more creative monitoring. Maybe that's a better method. So I think there were sort of trade-offs going there. As I say, there's not much appetite for a treaty, but I think states are also a bit worried that the Indigenous movement might push on that eventually. So this is a way through that. I'm not sure if that really answers your question, but it really was quite surprising, that extension of the mandate, albeit on the back of that World Conference in 2014. On your second point, sort of in the ideal world, how I'm not sure if I totally understood your question, Claire, but in the ideal world, how do you prevent unconstructive or ambiguity in that negotiating space? Is that right? Is that what you're sort of thinking about, to prevent that happening in a framework convention, like racing to the bottom rather than?
Yes,
Yeah.
I mean, I think, the texts on business and human rights which have emerged from the IGWIG process in some respects venture extremely detailed provisions, for instance, around how states should organize civil procedure in order to facilitate transnational private litigation as a form of remediation of business-related human rights abuses, which, of course, amongst other things, is potentially of relevance as regards Indigenous people's rights and abuses thereof. With the framework approach, on its face, there's much less detailed and much less prescriptive content as regards those and also other issues. So it's a concern for advocates that by supporting business and human rights framework convention, even if, because it's more expressed in a more open manner, it might enjoy greater support among states because there's more ambiguity to the provisions and how they should be implemented. In actual fact, the value of the instrument would be less because it does not entail necessarily the same changes to domestic legal arrangements, amongst other things, as would the sort of instrument on the table. So in that context, the notion of whether the question of whether ambiguity in primary legal text is going to end up being ambiguous constructively or destructively is sort of a key issue. So I just wondered to, perhaps you could say from what you shared with us, this was also a sort of compromise that had to be, faced up to in the context of the UN DRIP, whether to hold out for more detailed rules or to take the risks associated with a more open textured instrument. So in that context, could anything more have been done? as regards mitigating the scope for destructive ambiguity?
You know, as you know, and as I've mentioned, the negotiations went on for 25 years, and I do think that almost every avenue and every rabbit hole was gone down in terms of the various different trade-offs and all that sort of thing. I'm not sure that the declaration to have been agreed could have had, at least on self-determination, for example, any more detail. And I don't think it should have. So no, I don't think that there's many lessons to learn other than that every rabbit hole should be, every trade-off should be thought about. So can you get more detail that is better? Should be sought, of course, but if there's not, and at the end of the day you just need an agreement, that's the political reality of how these things go. I do think states and Indigenous peoples exhausted every opportunity, and there wasn't much. Yeah, there was. You could. That was about as good as I think they could got it. They could have it. So I'm not sure if there's any particular lessons other than take 25 years to get there, and you might exhaust all those possibilities and get to the best that you can get to.
Well, thank you. But you know, some of these are slightly rhetorical questions, you know, without clear answers. Okay. Perhaps if I can pass the word now to Annalisa, because I also notice that we are close to the end of the scheduled meeting time. However, I will propose to, for those that wish to and are able to extend by 10 minutes past our scheduled meeting time, because I don't want to curtail the time for discussion of Annalisa's presentation. But I'll pass the word to Annalisa. How then, from the perspectives of and your experience, both as a leading scholar as regards the interface of climate change and human rights, also as somebody with advocacy and practitioner experience, how would you be processing some of these questions as regards the relative merits and strengths of more prescriptive and less prescriptive instruments, and the architecture between overarching umbrella norms and subsequent instruments which may be able to be more prescriptive and address different topics in more detail?
Thanks, Claire. I'll stick to my 5 allocated minutes, and I will elaborate on what others have already said about multilateral environmental agreements, because many, not all, quite far from all, many of these are framework conventions. In the environmental context, framework conventions are used rather typically to address large-scale problems that states know will take a long time to resolve. So they don't go into this lawmaking process with the illusion that with one treaty they'll fix a problem, but they give themselves the time and space to deal with this problem over a long period of time. So what they do is to construct an architecture to deal with this problem. Some of these architectures have worked well. The Montreal Protocol to the Vienna Convention was mentioned. This is probably the most successful environmental treaty in history concerning the ozone depleting substances. But there have been other framework conventions, like the Convention on Biological Diversity, that have been far from successful, as the biodiversity crisis which we are experiencing clearly testifies, but also from a lawmaking perspective, what the parties to that treaty have managed to do is to very incrementally build on the original treaty basis, on very specific and technical issues. And this is where I was going to go with my intervention, because in the environmental context, these framework treaties have performed better on technical matters. The more technical, the better. So chemicals is a good example. There is a lot of treaties on the phasing out of various pollutants. The framework treaty, the mother treaty, sets up the governance frame, and then the various technical protocols adopted over time just add more substances to be phased out, more tables of timeframes in which these substances have to be phased out. So what these treaties do is really to create the governance mechanisms that take care of these issues over time. And I do not know how easily this can be transplanted in a rather different context, but you can imagine that here there will be a governance mechanism that over time develops rules that corporations have to comply with, and various monitoring mechanisms that enable the verification of compliance, because this is what you need international institutions for. You need international bodies that watch over states' shoulder and really tell them, look, you're not doing well enough. You have to revise your reporting procedures or your verification procedures. This has happened a lot, for example, with Kyoto. The Kyoto Protocol to the United Nations Framework Convention on Climate Change has many flaws, but for sure, it helped building capacity in countries with targets to do inventorying, that is monitoring of emissions of a certain quality, because nobody had done that before. And clearly it was a matter of building capacity amongst the parties to produce reports that were complete, reliable, that made sense and were scientifically sound. Again, I do not know how much this can be transposed into the business context, because we are clearly talking about something that is not so much natural science related, but more about other kinds of reporting. So I don't really want to talk for a long time, because I would also like to give time to the audience to say or ask any questions they might have. But I would just like to emphasize how complicated the governance mechanisms that these treaties have created over time is. The United Nations Framework Convention on Climate Change is one of the largest international bureaucracies in existence. The subsidiary bodies that have been created by the Conference of the Parties over the years are many, so many that most people don't even realize what exactly each body does. In other words, it is a process that is incremental, both in the lawmaking and in the institutional making. But sadly, not necessarily this continuous institution building is conducive to effectiveness. In fact, almost the opposite is true for the climate treaties. One of the mottos of the regime is, when the parties don't agree, they create another institution. And then, there is some political spoils and civil servants' jobs to allocate, and that will keep people happy for a little while longer. So I'm afraid this is not exactly a very optimistic tale I can tell about framework treaties, but as Jacques already mentioned, there have been important successes in the history of the development of international environmental law and framework treaties. So it's a bit of a half full, half empty picture that I like to paint for you here. And happy to take any questions on anything I've said.
Great. Well, the purpose of this series, is not to paint a rosy picture or to view, the world through rose-tinted glasses. We are here to explore both the merits and challenges associated with a framework approach to a business human rights treaty, and hope that we can learn from this exchange of experiences across sub-legal fields and of course from other disciplinary perspectives. So thank you very much to all of our panel for their respective inputs, and I think it's just shows that we are really just at sort of the beginning of a conversation that's needed to deepen and both broaden our understanding of the project that we're sort of engaged in here in discussing and promoting the idea of a business human rights treaty, and also gleaning what we can from many decades of scholarship and experience in government and in bureaucracy of working with and implementing and trying to advance the effectiveness of such instruments. So opening to the floor, we of course don't, because I have not been as disciplined as I would have liked as chair. We don't have as much time as I would have liked for questions, but if there are some questions, we can certainly take them now. And I'm not sure, just raise your hand. Ben, are you able to see if there are questions in chat or if people are raising hands?
No questions as yet, but do encourage everybody to.
Yeah, I will also open to the panel in case they have questions for other panelists. We won't have time for a round of closing sort of observations from the panel, unfortunately, on this occasion. But if you've got questions or observations inspired by each other's interventions, then we can certainly also take those briefly now. Barbara, yes. You may have to unmute.
There we go. I've unmuted myself. I learned so much from all of you. I took lots of notes, so I don't know where to quickly. Claire, I was just really struck by the constructive versus destructive ambiguity, and was this idea that it pushes it back into the domestic realm and you can get backwards movement. So I was just kind of curious if empirically you've looked at, anyone's looked at, or it would be useful to look at perhaps some of the variables that Beth Simmons identified in universal human rights treaties, that you get, you know, sometimes you get good news, sometimes you get bad news, and sometimes you get no news, right? Depending on regime type. And so in, you know, indigenous rights might actually, you know, get worse in the kinds of Saudi Arabias of the world, not change at all in the Canadas and the United States and most European countries, but in transitional regimes, maybe they actually, you know, I was just curious if there might be a similar pattern. And then second, what the ILO is older than all of us. Thank you, Professor. I feel young suddenly. And I was kind of struck, like ozone, ILO, involved businesses, right, in the actual negotiations. Like kind of revolutionary for the ILO to be so old and to really take sub-state actors, labor and business, so seriously in both the negotiation and the implementation, and if that is something that is also really important going forward. So I'll mute myself.
Yes, not only old, but also tripartite. That's very important. The business people are there in drafting all the treaties and so on. Both employers and workers are fully represented with equal footing, voting rights. That's very important.
Thank you. And maybe Claire, do you want to come back on the question? Claire, you're on mute. Could you unmute yourself?
Sorry about that. Thanks for your question, Barbara. And I was equally sort of intellectually curious about a number of the points that you raised, and I can see some synergies in around the Indigenous drafting process from the declaration and some of the points that you were making. Yeah, on the whether constructive ambiguity has led to a backsliding on declaration rights or not. There is quite a lot of empirical analysis, particularly in places like Canada, New Zealand, Australia, and so on, but less so globally. So it is difficult to make a global assessment. To some extent, I don't think that interpretations by state bodies, by courts, etc., have ever lived up to what Indigenous peoples would have hoped that that would have hoped for in terms of their own interpretation, to the extent that there's different interpretations. But I do think that there is some upwards movement because of the international monitoring, which is not just saying New Zealand, you're not doing enough here, there, or elsewhere, but is also trying to say, well, that state's doing a bit better than you, so maybe you should move in that direction, which I do think gradually starts to impact at a domestic level to mean that there is that convergence upwards as well. But it really depends so much on the political context domestically, of the openness of the state and so on, and the relationship between the states. So I do think between Canada and New Zealand, for example, there is this convergence of opinion that is going upwards. They're kind of feeding off each other. But that's not true of New Zealand influencing Africa so much, even though the expert mechanism might be saying, well, there's synergies, or you're doing that, so there's an awareness. So it's a complicated picture. There is some empirical work, but really it's in silos and geographically.
Thanks, Claire. And I see we have got one question in the chat. I don't know to whom it was addressed. We should have flagged that should be done in questions. Juan Nguyen, do you want to identify who it's to be addressed by, this question? If you're still with us, the question is, do you think the regime of corporate liability within a business and human rights treaty is possible to achieve? My own take would be that provisions regarding corporate liability could eventually be achieved, but I don't think either that the United Nations necessarily right now is the optimal institution for transacting such rules. I think there's the Hague Convention as a platform as regards civil liability, which might be more appropriate, but equally perhaps in time with greater convergence in relation to other key concepts and elements, for instance, on mandatory due diligence rules and regimes and how they should be designed and applied, then perhaps it would be possible to move gradually in that direction. But I think that making the sine qua non of a business and human rights treaty, detailed and extensive rules on corporate liability, will be very, very technically challenging and also diplomatically an uphill struggle, given simply the diversity of national legal rules and systems and the issues that are raised in that conjunction. But perhaps any of the other speakers wish to comment on that point?
Yes, I'm happy to make a quick comment.
Yes, please, Jacques.
I think in general it's a very difficult time for human rights treaties. So there's a lot of pressure on global human rights treaties like the 1951 Refugee Convention. There's regional pressure, for instance, the European Convention of Human Rights. And it just doesn't seem like an auspicious moment, basically, to be negotiating a new human rights treaty. It looks like we have to have all hands on deck just to protect the ones we have. And unfortunately, that's a very low empty glass that I'm presenting there, but I think that's the truth at the moment.
And Juan Nguyen, if you're still with us, do you want to answer? No obligation to do so, but if you would like to comment or contribute, we can hear from you briefly now. No, okay, well, thank you very much to everybody for contributions today. I will just close by highlighting that our next seminar will be on Thursday, the 30th of September. Will be on the 23rd of September, next Thursday. There we will look at contours and challenges of a framework treaty from largely the experience of other sub-legal fields. And thank you, Ben, for putting these details also in the chat. We will have as our panelists next week Professor Peter Mcklinski from SOAS, Eva Juepner from the University of Dundee, Dr. Alex Ansong from the Ghana Institute of Management and Public Administration, Markus Krajewski from FAO in Germany, Nicolas Bueno from Unidistance in Switzerland, Olga Martin Ortega from the University of Greenwich, and Professor Humberto Cantu Rivera from the University of Monterrey in Mexico. So clearly I will have to be much more on my game as chair if we're going to equitably distribute limited time available in the next seminar to cover all those experts' input and also to allow for a slightly more extensive discussion, I hope, with participants. But thank you again, everybody, and I look forward to see at least some of you again next week.
Thank you.